Members of the jury, Mr. Nelson, can I have you move the podium for me, please?
Yes, sir.
Just slide it underneath the pole there.
Sure.
Thank you. Perfect. Thank you very much. You will recall at the beginning of this trial, several instructions were read to you on trial procedure, on your duties, and on some of the law to be applied to this case. Those instructions should be considered by you as part of the remaining instructions that I now give. Officer, please don't let anybody in that door while I'm reading these. Thank you. While you are the sole judges of questions of fact in this case, it is your duty to accept the law as is given to you by the court in these instructions, and to apply the law to the facts as you find them to have been proved. You have no right to disregard the law and look for any theory unsupported by credible evidence upon which to build a verdict based upon your notions of what the law is or ought to be. A person who knowingly or intentionally causes the death of another human being, or who willfully causes the death of another human being under circumstances manifesting extreme indifference to the value of human life, is guilty of murder. The state's burden of proof is satisfied if the evidence shows beyond a reasonable doubt the following essential elements. On or about June 3rd, 2007 in Ward County, North Dakota, the defendant, Nichole Rice, intentionally or knowingly caused the death of Anita Knudsen, a human being. Or the defendant, Nichole Rice, willfully caused the death of Anita Knudsen, and the death of Anita Knudsen was caused under circumstances manifesting extreme indifference to the value of human life. A person engages in conduct intentionally if, when he engages in the conduct, it is purpose to do so. Knowingly, if, when he engages in the conduct, he knows or has a firm belief, unaccompanied by substantial doubt, that he is doing so, whether or not it is his purpose to do so. Recklessly, if they engage in conduct in conscious and clearly unjustifiable disregard of a substantial likelihood of the existence of the relevant facts or risks, such disregard involving a gross deviation from acceptable standards of conduct, except that awareness of risk is not required when its absence is due to self-induced intoxication. Willfully, if he engages in the conduct intentionally, knowingly, or recklessly. When a person is charged with having been present and with having committed or aided in committing a crime, absence from the scene of the crime is a complete defense called an alibi. Intent may be proved by circumstantial evidence. Indeed, it can rarely be established by any other means. We simply cannot look into the head or mind of another person, but you may infer the defendant's intent from all of the surrounding circumstances. You may consider any statement made or act done or omitted by the defendant and all the facts and circumstances in evidence which indicate the defendant's state of mind. In this case, you have observed video evidence. When considering video evidence, you should evaluate it like any other piece of evidence. And you may consider any facts or circumstances in the case which tend to strengthen, weaken, or contradict the video evidence. You should consider the video evidence using your common sense and experience. The opinion of an expert is based upon certain underlying facts or data. While you need not accept that opinion, you should consider it and give it such weight and credibility as you think it deserves in the light of all the circumstances. If you conclude that the opinion is not based on sufficient education or experience, or the reasons given in support of the opinion are unsound, or the opinion is outweighed by other evidence, you may disregard the opinion. Witnesses who were not testifying as experts gave testimony in the form of an opinion or inference based on having perceived a matter. In deciding the weight and credibility, if any, to be given a witness's opinion or inference based on having perceived a matter, you may consider the witness's opportunity to have perceived the matter, the witness's reasons for the opinion or inference, and all other evidence related to the issue. The weight of the evidence is not determined by the number of witnesses testifying on either side. You should consider all the facts and circumstances in evidence to determine which of the witnesses, if any, are worthy of belief. You may find that the testimony of a smaller number of witnesses on one side is more believable than the testimony of a greater number of witnesses on the other side. Any fact in dispute may be proved by the credible testimony of a single witness. However, before finding any fact to have been proved solely by the testimony of a single witness, you should carefully consider all of that witness's testimony upon which proof of fact depends. A witness, including a party, may be impeached, meaning that the witness's testimony is discredited by contradictory evidence you find to be true, or by evidence that on a former occasion the witness made a statement or acted in a manner inconsistent with the present testimony, or by evidence of conviction of a crime, or by evidence of character for untruthfulness. If you conclude that a witness has been impeached, you may give the testimony of that witness such weight and credibility, if any, as you think it deserves. If you conclude that a witness has been impeached by an earlier contradictory statement, the statement may be considered by you as evidence only if the statement was given under oath, in which event you may determine which is the truth, the present testimony or the earlier statement. If you conclude that a witness has willfully, knowingly, or intentionally testified falsely concerning a material fact in this case, you may wholly disregard the witness's testimony unless it is corroborated by other credible evidence. A defendant has a constitutional right not to testify. You must not draw any inference of guilt from a defendant's silence. The prosecutor cannot mention a defendant's silence, and you must not discuss or consider it. If you find from all the evidence in this case, beyond a reasonable doubt, that all of the foregoing essential elements of the crime charged in the information, viewed in the light of the law, have been proven, then it is your duty to find the defendant guilty. If the state has failed to establish any of those essential elements beyond a reasonable doubt, it is your duty to find the defendant not guilty. In reaching your verdict, you must not discuss or consider any possible penalty or punishment, as that matter lies with the court and other government agencies. When you go to the jury room, you will select a jury leader. The jury leader will lead your deliberations, communicate with the bailiffs for you, and speak for you in court. The jury leader does not have more authority than the other jurors, and the jury leader's opinion does not carry more weight than the opinions of the other jurors. In order to return verdict, each juror must agree to the verdict. Your verdict must be unanimous. It is your duty to work with each other in an effort to reach an agreement, if you are able to do so without giving up your individual judgment. Each of you must decide the case for yourself, but you should consider the evidence impartially with the other jurors. You should not hesitate to change your opinion if you are convinced it was wrong. But you should not change your opinion about the weight or effect of the evidence just because of the opinion of other jurors or in order to return the verdict. If it becomes necessary for you to communicate with me during your deliberations, the jury leader should send a note to the bailiffs. All questions to the judge must be reviewed by the attorneys. This may take a period of time, and some questions may not be answered. After you have agreed on your verdict, the jury leader should fill in, date, and sign the formal verdict using the appropriate form which accompanies these instructions. The jury leader should then notify the bailiffs that you have reached your verdict. You will be brought to the courtroom for reception of the verdict. You must not disclose your verdict to anyone until it is returned in open court. One form of verdict is submitted to you for finding the defendant Nichole Rice not guilty or guilty of the offense of murder. You will now take this case, try it fairly and impartially between the state of North Dakota and the defendant, and return such verdict as is warranted under all of the evidence and these instructions. Dated the 25th day of March, 2025 by the court, Richard L. Hagar, District Court Judge. Ladies and gentlemen of the jury, I was in charge of your life. Now you are in charge of mine. Can I have the bailiffs come forward, please? Thank you. Can I have you raise your right hands, please? Do you solemnly swear to keep the jury together until they are returned to the court and not permit anyone to communicate with them unless you are directed to do so by the court, so help you God? Thank you very much. You may lead them out now.